case number 112059 in the matter of Peter Edward Collis.
May it please the Court, Stan Hasler, appearing for the Disciplinary Administrator's Office. Mr. Chief Justice, I'd like to reserve 2 minutes.
2 minutes is granted.
We're here as a result of a hearing that occurred on May 7th of 2014. The respondent appeared in person at that hearing and with counsel John Ambrosio. The Disciplinary Administrator's Office appeared through Dustin Slinkard at that hearing. Mr. Slinkard has now left our office and gone back to the U.S. Attorney's Office, so I'm filling in for him today. On July 22nd of 2014, Respondent's counsel, Mr. Ambrosio, filed a notice pursuant to Supreme Court Rule 212 stating that he didn't take exceptions to the findings of fact made by the panel in this case, but reserved the right to talk to the Court today about the appropriate discipline. The panel found violations of Rule 4.1 by knowingly making a false statement to a third person, actually 2 people, and KRPC 8.4C engaging in conduct involving dishonesty. The panel found that the respondent engaged in misconduct due to multiple affirmative misrepresentations made on 3 occasions, but in a voicemail, in an email, and over the phone to 2 different people, one being a lawyer, one being a layperson. The misrepresentations were made with respect to the status of a personal injury case where the respondent was representing his client in a personal injury case, saying essentially that we were still involved in settlement negotiations when in fact the case had been settled sometime before. With respect to the recommendations made by the various parties involved, the panel recommended censure. 2 of the panel members recommended that censure be non-published. One panel member recommended that the censure be published, stating that, in her opinion, that it was important for the public in a bar to know the respondent's conduct and that the respondent had experienced consequences as a result of that misconduct. The respondent requested censure. My guess is that the respondent will argue to you today that they would prefer the non-published censure. The Disciplinary Administrator's Office recommended a 3-month suspension. Based on the 3-month suspension was based on the multiple misrepresentations to 2 different individuals. Mr. Slinkard said in his closing argument, that there's a real importance of lawyers being able to rely on the honesty of other lawyers during negotiations. The panel made reference to the difficulty in deciding the appropriate discipline in this case. They pointed out in the final hearing report that the respondent's request for discipline, the recommendation of the panel, and the disciplinary administrator's request were all, you could argue that they were all supported by the ABA standards on lawyer discipline. In fact, they cited in their panel report 2 standards that they say could apply to this case. One which would support reprimand, and one which would support suspension. And they say in their panel report, clearly the recommendations of both parties are supported by the ABA standards as listed above. I am arguing today to this court that standard 7.2 applies, which would suggest that a suspension is appropriate under the circumstances of this case. The respondent's conduct was a violation of the duty owed as a professional, which is set out in Rule 7.2, Standard 7.2. That being the candor of opposing counsel that being the duty of opposing counsel to exhibit candor towards counsel during the negotiation process. Failure to do that does cause an injury to the profession as contemplated by Standard 7.2. 7.2 also requires at least potential injury to a client or the legal system. In this case, when the lien holder in the personal injury case found out that it had been misled by the respondent, it responded to counsel as follows. Because it appears now that my client has not been negotiated with in good faith, the plan is not willing to reduce its lien or right to full reimbursement / subrogation. Accordingly, my client requires full reimbursement in the amount of $228,000. So the panel, there was potential injury. The panel recognized that there was potential injury. They stated in their panel report that as a result of the respondent's misconduct, the respondent may have caused injury to his client as the lien holder stopped negotiating after learning that the respondent was not negotiating in good faith. Further, the respondent caused actual injury to the reputation of the legal profession by making the false statements. For these reasons, I believe suspension is appropriate. As I viewed this case, as I read through the transcript, because I was not trial counsel, I really felt like a 6-month suspension would have been appropriate. But as I read more closely, I noted that the respondent did not find, that the panel did not find any aggravating factors on the part of the respondent. And those lawyers who were there on the panel who observed the respondent indicated in their panel report that they felt that there was genuine remorse on the part of the respondent. So as I viewed all of those factors, I felt that a 3-month suspension was appropriate, as Mr. Slinkard recommended to the panel at the hearing. And that is my recommendation as I stand here today. I'm happy to answer any questions.
Any questions?
The amount of the lien had no impact on attorney fees?
I don't believe it did. The respondent was limited to 25% recovery under federal statute, and it was a $416,000.
And that's of the gross, so the lien didn't matter?
Correct.
Right, okay.
Any more questions? Thank you, counsel.
Thank you.
John Ambrosio on behalf of the respondent, may it please the court. Start right from the beginning and tell you we do not fault the panel and what they found as far as their facts. We do not fault the panel or disagree with the panel as far as the rules violation. No question that they're absolutely dead on about that. We accept either the majority suggestion or the minority suggestion, but of course we would be more happy with an unpublished censure. This young man, I can say that now that I'm 67 years of age, because he is young, is a good lawyer, a bright lawyer, and works hard for his clients. He has no prior record, has never been in trouble, not even a letter of caution, not even a complaint. And I think it's important that we look at the panel report because they indicated he was not selfish or dishonest. Look at paragraph number 32 when you caucus. It says, absence of dishonest or selfish motive. While the respondent engaged in dishonest conduct, the respondent's motivation for the misconduct does not appear to be based on dishonesty or selfishness. The respondent's explanation for his misconduct at the hearing was twofold. The respondent testified that he may have been frustrated with the lien holder, or he may have been trying to help his client. And to answer your question, he did not even get the full 25% that he was entitled to under the Tort Claim Act. He took $80,000. He renegotiated his fee with his client after he had paid the lien and after all of this mess occurred. This is
that to make amends for the position that the lien holder took, the firmer position that the lien holder
I apologize. I did not hear you first.
Was that to make amends or to work out the money problem after the lien holder stood firm on its full amount?
Perhaps.
I mean, in other words, I caused a problem, it cost money, I ought to take it out of my fee rather than...
I think that's correct. I'm speculating, and I think he would have reduced his fee anyway because the lien was so large, the SAP lien was so large that his client was not going to receive a lot for a devastating injury. I always hate to quote, because I know you have your briefs in front of you and you have your law clerk briefs in front of you, but I want you to read 38, 39, and 40 of the panel report. They indicate in number 38 that this appears to be out of character for my client. This is something that he wouldn't do again, and they couldn't believe that he did it in this case. Number 39, the hearing panel had the opportunity to observe the respondent during his testimony. He was devastated. He was teary-eyed. I don't mean to embarrass you. He was crying. As a matter of fact, the panel was so worried about him, they got word to myself and to my colleague the same day what they were going to do. They did not want him to wait the 6 weeks or 5 weeks it would take for the panel hearing because they were worried about him because he was so remorseful. And number 40 in the panel report says that it is unlikely that the respondent will repeat the misconduct. And I know you hear that up here all the time. We hear it at panel hearings. We heard it yesterday. Well, we always hear this. And it's easy for lawyers to say, you won't see me up again. I'm sure if I'm ever up here, God forbid, that I will say the same thing. The panel really felt that this young man was sorry for what he did, was remorseful, he was a good lawyer, the character evidence was terrific for him, and they thought he made a mistake. I agree with the Disciplinary Administrator's Office as to the application of 7 point whatever it is, I always forget these rules. I understand that, but you also can give him a public censure or censure that is not published and still send the message. The message needs to be sent to him, and he has heard this message loud and clear. He won't be up here again. He made a mistake, albeit a terrible, terrible mistake that a lot of us would never have made. He felt for his client. He should have negotiated that LIN prior to the settlement. There's no doubt about that. He knows, and he's going to tell you that he was wrong about that, but he deserves this chance. That's all I have to say. My client would like to address you.
Before we get into that, counsel, as I read the record, this was not a self-report. This was a complaint filed by the lien holders' lawyers for Satt Brothers. Is that right?
Mr. Chief Justice, that is correct.
Okay. And so my question is, when did your counsel realize I should not have done this from an ethical point of view? Or is that something he'll need to tell us?
I think you should ask him. My feeling is that he didn't realize until that letter was sent to the Disciplinary Administrator's Office and he got the gray envelope from Mr. Hazlitt's office that indicated you've done something wrong. I didn't even think it had dawned on him to that point in time. And since that time, since he received the letter, he has been doing everything he can to do away with this transgression and to work hard at this for forgiveness is what I'm saying. So you're absolutely correct on that.
All right.
With
Thank you.
your permission, he would
Yes,
like to
please.
address the panel.
Chief, if I may answer that question, after I had been negotiating the lien with Ms. Gutah Fox, and prior to her sending me a letter requesting the full lien amount, I was contacted by defense counsel that Ms. Gutah Fox had contacted defense counsel asking for a copy of the release. They asked me for my permission to send that release to Ms. Gutah Fox. At that time is when I realized it, and I told told defense counsel it was okay to send that release.
When you say I realized it, what does it mean?
That I had done something that was very inappropriate, and I had done something that was in a violation of the rules, and I want the court to know how sorry I am for doing this. You know, I wanted to be an attorney since I was a little boy, just like my dad, and he always taught me that this is a great profession. We need to hold ourselves to a higher standard, and I think I've done that throughout my career, except in this one instance. I know that I've let the profession down, and that's something that I take very seriously. And I want to apologize to the lawyers of this state, to the lawyers of the state of Missouri where I also practice, and all the lawyers in Kansas City where our office is located. This was something that was inappropriate, something that was not necessary, and something that I should not have done, and I'm fully aware of that. I want to also apologize to my law partner, Sam, who's here today, for putting him through this. When we started our practice 8 years ago, we said we were going to do it the right way, and I think we have. And except in this one instance, and I want to apologize to Sam, who's here today. I want to apologize to my family as well, and my dad. That's a hard phone conversation. My wife and my dad wanted to come today, but I wouldn't let them, but I have a feeling I know they're watching, so I want to apologize to them for putting them through this. So I just want to let the court know that I'm very sorry. I know what I did was wrong, and I'm willing to accept whatever decision is made here today. Thank you.
When the court decides how we're going to proceed in terms of level of discipline, if the past is an indicator, I think some of us may wonder if, according to the findings of fact made by the panel, which you and your counsel take no exception to, it says you made false statements of material fact in the voicemail message, in the electronic mail message, and during a telephone conversation. And then my understanding from what you've said a few minutes ago is that once you learned that defense counsel had been contacted by the lien claimant's lawyer, that's when you learned that you had done something you had been incorrect. So my question is, what was there in your life or in your practice up to that point that led you to believe that lying 3 different times was something that was appropriate?
Well, I don't think it was appropriate. I think that I realized the severity of my actions. I think my colleagues in Kansas City that I practice with and I opposing counsel will agree that I'm very honest with them when dealing with cases. I think this was an instance where I was frustrated that I couldn't get a decision from the lien holder. I had spent several weeks trying to find even the right person to talk to about it. I think I was my judgment was poor because I wanted to get my client the most that he could get to take care of him for the rest of his life for his horrible injuries. I think it was that lack of judgment that caused me to do this. And I think when defense counsel contacted me, I realized the weight of my actions and the severity of my actions. And it's been a long year. It's been a long year dealing with this because I hold myself to a higher standard than this. And I know this isn't me. And everybody else should hold me to a higher standard. My colleagues, my friends, my family, my law partner. I've let them down, I've let me down, I've let all of us down.
All right, thank you. Any more questions of either counsel?
This can go to either counsel. I don't have enough of the file right in front of me here on the computer. As I see the hearing panel report, the call to the U.S. Attorney's Office was on April 8th. So I'm assuming that the U.S. Attorney's Office contacted the respondent shortly around April 8th to get permission to send it. And then SAP on April 11th demands the full amount. The respondent on April 16th asked for an itemization. And then the disciplinary administrator files a complaint on May 7th. I'm trying to figure out of all that, when did SAP file the ethics complaint? And really what I'm getting at is you get the call from the U.S. Attorney's Office on the 8th of April and you don't self-report. And it looks like we're not self-reporting at all. But a lot of time is going by. I'm just trying to figure out when the disciplinary administrator got notice of this. So that's my question, and he's got rebuttal. If you don't know the answer,
I don't know the answer because they stamp
he can
their
answer.
complaints in. I don't
He can
have that
answer
with
that one. But you see
Okay.
my point. And so you get that call from the U.S. Attorney's Office, you've got to know the gig's up. And we don't have self-reporting here. So I'm trying to factor that into the remorse, which is going to factor into whether unpublished, published, or what he wants to do over here.
You have to stand for
You
the
see what I'm saying?
Mm-hmm.
So
Why didn't you self-report?
what's hanging us up about self-reporting this conduct?
Quite frankly, I just didn't even think about it. I was neglectful, and I should have self-reported. There's no self-reporting in Missouri, but I've already contacted them through counsel when I got the complaint from the disciplinary administrator's office. I am also licensed in New Jersey, and I've contacted them as well.
15, Exhibit 15, date stamp 37, it indicates received August 5th, 2013 is the stamp. Did I read that correctly?
Did I get the complaint right?
That's the complaint by the lawyer for SAP, the lien holder, to Ms. Dengler. The real,
Formal complaints later.
much later.
Yeah.
So August. Yeah, okay.
Any more questions? All right, thank you, counsel. You reserve 2 minutes for rebuttal.
Unless the court has any questions, I would waive rebuttal.
Any questions? Thank you, counsel. Thank you all for your arguments this morning. Court will take this matter under advisement.